we will hear from two individuals who were involved in the external panel on options for a legislative response to Carter versus Canada. We have Mr. Benoit Pelletier, who was a member of the external panel, and we have Mr. Stephen Meharan, who is the Executive Director of the Secretariat. This session will end no later than 6:30 p.m. and you have 10 minutes for your presentation.
Merci, merci, Monsieur le Président.
Thank you, Mr. Chair, and honorable members of the committee. I would like to thank you for the invitation to appear before you on this most important of issues.
Thank you, Mr. Chair, and honorable members of this committee for the invitation to appear before you on this most important of issues. I will be speaking mainly in English, but there will be paragraphs that I will repeat in French. These were paragraphs that I chose for their significance. Je vais donc m'exprimer dans les deux langues officielles.
I will be using both of Canada's official languages, but mostly in English.
I'm a full professor at the Faculty of Law of the University of Ottawa and a member of the Bar of Quebec. I appear before you this evening as the representative of the three-member external panel on options for a legislative response to Qatar. The chair of the external panel is Dr. Harvey Max Chochinov, Canada Research Chair in Palliative Care, and the third member is Catherine Frazee, Professor Emerita at Ryerson University. They are out of the country but are following these proceedings closely and would be available to assist this committee going forward. I am pleased to appear on their behalf and with their full support, and I will do my best to represent our work. I am also assisted this evening by Mr. Stephen Mihorian, the Executive Director of the panel's Secretariat. And for the record, my co-panelists and I would like to recognize the substantial contribution we received from the extraordinary group of professionals in the small secretariat that supported our work. I would also like to take this opportunity to thank the government, past and present, for the confidence placed in us to do this work. The external panel report is detailed and complex because the issues related to physician-assisted dying are detailed and complex, and these issues require consideration and thought in determining sound social policy. This committee has been provided with copies of our report, which I will not have time to review in detail, instead highlighting some of what we heard in a series of long meetings with interveners, medical practitioners, and regulators, academics, government representatives, and civil society organizations, as well as two of the individual claimants, Ms. Lee Carter and Mr. Hollis Johnson, and another claimant, the British Columbia Civil Liberties Association. The complete lists of those we met with in Canada, the United States, the Netherlands, Belgium, and Switzerland are found at Annex C and D of our report. As well, abstracts of transcripts from these in-person consultations are found at Annex E. The panel also reviewed a total of 321 formal document submissions, which are summarized at Annex F and chronicled with brief individual abstracts at Annex G. I would like to say a little about what we learned in Europe. There appears to be a general satisfaction with the law in the countries we visited. We were told that assisted dying works well in the context of a robust social safety net well-funded healthcare services, and high levels of trust in physicians. At the same time, there is intense controversy about cases that push the boundaries, test the limits of the law, cases that challenge the age requirement, cases involving advance directives, cases that arise from psychological, existential, or psychiatric suffering or suffering related to chronic conditions that are not life-threatening. For many people, one of the most important safeguards is transparency. Mistakes and abuses must be detected and acted upon, likewise non-compliance with reporting requirements. The panel's online questionnaire was completed by almost 15,000 Canadians. I would like to draw your attention to our analysis and the results of this public consultation, which provides a rich source of information and insight, and which can be found in Annex A of our report. For example, participants demonstrated strong levels of approval for palliative care education for all healthcare providers, for better support for disabled people, for better home care, palliative care, and end-of-life care in the whole country, and for an efficient oversight of physician-assisted dying. The questionnaire also revealed that respondents were more likely to agree that physician-assisted death should be allowed when a person faces significant, life-threatening, and/or progressive conditions. And the questionnaire demonstrated that participants were generally very concerned about the risks that existed for people who are mentally ill, especially those with episodic conditions, and for persons who are isolated or lonely. Voici donc les résultats du questionnaire.
These are the results of the questionnaire that we put online and which solicited more than 15,000 responses from Canadians. For example, participants demonstrated strong levels of approval for palliative care education for all healthcare providers, for better support for disabled people, for better home care, palliative care, and end-of-life care in the whole country, and for an efficient oversight of physician-assisted dying. The questionnaire also revealed that respondents were more likely to agree that physician-assisted death should be allowed when a person faces significant, life-threatening, or progressive conditions. The questionnaire also demonstrated that participants were generally very concerned about the risks that existed for people who are mentally ill, especially those with episodic conditions, and for persons who are isolated or lonely.
On some issues, we found high levels of agreement among Canadians from diverse perspectives. For example, there was agreement with the idea that all Canadians who suffer should have access to supports and services that are within our capacity as a nation to provide, whenever they're alive and whatever their personal circumstances. There was agreement with the idea that Canadians should invest trust and respect in an assisted dying regime that features transparent, accurate, reliable, and objective oversight through data monitoring, research, and public reporting. Honorable members of this committee, we reported on the points of view that were expressed to us, but our report is not just an account of those exchanges. Our report contains much information and analysis on the issues. We heard clearly that there is a need to balance individual autonomy and the protection of vulnerable people. This being said, I would like to say a little more about autonomy and vulnerability. With respect to autonomy, there are a number of what I would characterize as core values that inform the Carter decision. Among them are the integrity of the person, dignity, self-esteem, and the right of an individual to make important decisions regarding his or her end of life.
1 minute.
Awesome.
1 minute.
1 minute? Oh boy. Okay. I will do my best to summarize then the rest of my presentation, Mr. Chair. En ce qui touche donc à l'autonomie, j'aimerais souligner qu'il s'agit d'une
With respect to autonomy, I would like to. There are a number of what I would characterize as core values that inform the Charter decision.
and subtle concept. Although the phrase vulnerable populations has been used to describe certain identifiable groups in society, the panel heard from many sources that vulnerability is not simply a characteristic of an individual or group, but rather is a state that any one of us could be in under certain circumstances. We heard that sometimes people are made vulnerable in particular contexts and situations when personal autonomy, status, wealth, and well-being are compromised in any significant way. What this means in the context of physician-assisted dying is that all persons are potentially vulnerable. Being vulnerable does not disqualify a person who is suffering intolerably from seeking an assisted death, but it does put that person at risk of being induced to request a death that he or she does not desire. This is the risk that the Supreme Court called upon Parliament and provincial legislatures to address in a complex regulatory scheme. Concerns were raised about access to physician-assisted dying, particularly for people living in Canada's remote communities. Concerns were also raised about how Indigenous people will respond to physician-assisted dying. There were, of course, many questions about which there were competing visions. If I may, Mr. Chair, for example, does grievous and irremediable need further definition in legislation, or should physicians and their regulatory bodies have the discretion to interpret these terms? Should the decision to provide an assisted death be subject to review, and if so, should that review take place before or after a request has been granted? Are protections for vulnerable people or persons required beyond those routinely in place for patients wishing to refuse or withdraw life-sustaining treatment? How should the overlapping jurisdictions of provinces and the federal order of government be addressed? The establishment of eligibility criteria, possible definition of key terms, and implementation of appropriate safeguards to protect vulnerable individuals are theoretically the responsibility of the various governments and legislative assemblies. In this regard, the Canadian population expects collaboration between the federal government and the provinces and territories so that the division of responsibilities, the implementation of physician-assisted dying, and its oversight are managed in a consistent and effective manner. While most attention has been given to physicians, other health professionals may be called upon to participate directly or indirectly in physician-assisted death. In this context, it may therefore be important to examine whether laws, rules, and protections should be extended to these other professionals. Honorable members of this committee, my co-panelists and I agreed to serve because we wanted to contribute to our country as our country is in the process of making critically important decisions on this sensitive and challenging topic. Our extensive consultations and work, including the report before you, was completed and delivered to government within 5 months. Our panel wanted to advance the debate and to make sure that everyone, from citizens to the members of parliament, to federal ministers, and to provincial and territorial elected officials or representatives, had access to all relevant perspectives and information. Above all, Mr. Chair, we wanted to assist this Parliament in making informed decisions. I hope that the report of our panel and my testimony today will facilitate this committee's work. In conclusion, I would like to signal for you, members of this committee, that as I am appearing on behalf of my co-panelists, there will be occasions today when I will respond on behalf of the panel, and there will be times when I will be giving my personal opinion. When those latter situations arise, I will say so. Those are my opening remarks. Thank you. I would be happy to take any question you may have in the official language of your choice.
Thank you. Monsieur Lemieux.
Monsieur Pelletier,
Mr. Pelletier, first of all, please allow me to congratulate you for the excellent work that you have accomplished last year. I know that the Liberal government changed the committee's mandate in order to withdraw from the mandate the requirement to present options, legislative options, with regards to the Carter decision. Yesterday, Jean-Pierre Ménard appeared before us. He suggested that we deal with the Supreme Court's decision in two steps. First of all, to deal with 241B and 14 of the Criminal Code in order to implement them, in order to include medically assisted dying, and to implement a detailed process throughout Canada to allow provinces and territories in Canada the time to legislate on all of the other aspects of medically assisted dying. We also mentioned that the other questions are of provincial and territorial jurisdiction. What do you think of this suggestion made by Jean-Pierre Ménard? Thank you. I think that it is a good thing to indicate that physician-assisted dying is an issue that can require many interventions from the Government of Canada. Regardless of what the Government of Canada does, what is desirable is for there to be cooperation with provinces and territories. I would say that what must be at the heart of what this Parliament does is the principle of cooperative federalism, which the Supreme Court often referred to, and which is a very healthy principle to apply to Canadian federalism. The most urgent matter is, without a doubt, to change Canada's criminal code. It needs to be changed in order to comply with the Carter decision. Even if the Parliament did not do so, the Carter decision would have primacy over the suspension of the decision's application, which means that the decision would apply as of June 6th, and the Carter decision would be the ruling principle. Even if the criminal code were not amended, we would have to interpret it as such. There may be dispositions that refuse physician-assisted dying. That being said, this most significant question is to ask how far the federal government wants to go or should go in terms of leadership in the file of assisted dying. This leadership has been requested. Some Canadians even wish for there to be a certain uniformity when it comes to the measures that can apply in the physician-assisted dying file. But as you have indicated, provincial powers do matter in this case. Therefore, the federal government will have to take into account this provincial presence and will have to reconcile it. Thank you.
Mr. Marois.
Thank you, Chair. Thank you for the witnesses and to the panel in its entirety for the work that you have done, the hours of consultation, and for the report and its timely release. I was particularly interested and appreciated the amount of involvement that we saw from Canadians. 15,000 Canadians participated in this. And the key findings that you have in this document that you've shared with us. If you could share with us what those key findings were, in particular, in what were Canadians saying? What was the strong support that you heard in relation to people that were dealing with suffering through a mental or psychological illness? My understanding in the report was that there was much greater support if it was a physical, not mental issue regarding the suffering, and also that I believe the report was showing a very much stronger support if the illness that we're dealing with, the suffering, dealt with a life-threatening progressive condition that was terminal, and again, not a mental, and not a temporary suffering, but a definite prognosis was it was a progressive terminal illness. If you could elaborate on that, on the mental issue, and whether it is Canadians are saying, majority, that or the stronger support seems to be that it be a physical, terminal, progressive illness.
Yes, thank you very much. I would say that what I will say comes from the 15,000 people who answered the questionnaire, and also from the consultations that we had all over Canada. Because, as you know, we met many experts and groups and associations and so on. There is a concern that expressed many people about the application of physician-assisted dying to people who suffer from psychological illnesses. It is clear that the support for the application of that physician aid in dying in the case of physical illnesses or physical disabilities, for example, the support of the population is stronger than in the case of psychological illnesses. At the same time, I should say that a priori, the Carter decision does apply to psychological situations, maybe as well as to physical situations. I say as well as to physical situation, but this still has to be determined to an interpretation of the decision. But I would say that prima facie, the Carter decision applies to both psychological and physical illnesses. And respondents were more likely to agree that physician-assisted death should be allowed when a person faces significant life-threatening or progressive conditions. So if someone suffers significant life-threatening or progressive conditions, then the support generally of the population is stronger than in a case where we're not in such a situation and a person has many, many years to live before her. But I'd say that it's the challenge that this Parliament should face. And this is the challenge that is, I would say, that flows from the Carter decision. The Carter decision does apply to assisted suicide and voluntary euthanasia It does apply to psychological and physical illnesses. It does apply to situations where someone is not confronted to the end of his life. So that decision is quite large. That decision is quite wide in its scope, I would say. And the challenge for this Parliament and the provincial legislatures is now to see if there should be limits to that decision. And again, if there are limits to that decision, those limits should not, I would say, go against the spirit of the decision. Because, of course, due respect for the decision of the Supreme Court of Canada is necessary in this case.
Thank you, Mr. Pelletier. I'm going to remind everyone that we have a 5-minute time limit for the question and the answer. Mr. Rankin.
Thank you, Chair, and thank you, Professor Pelletier, for your remarks. I note that you've spent in Chapter 2 of the report a great deal of time on federal-provincial issues, and today you've also spoken about the fact that the population expects collaboration between the federal and provincial governments. Yesterday, Professor Hogg testified before us, and he was reminding us that the federal government must establish its own regime. It cannot count on the provinces to step in. They may not. We have a constitutional duty, he said, to remember that it's from coast to coast to coast that we're doing this work. And he had a suggestion, and I would like your reaction to it. It was that we have a system where the federal government cabinet or the Minister of Health might declare substantially similar provincial regimes like that of Quebec in the event that they pass muster. And he told us of 2 other federal examples where that process had been done. I'd like your reaction to that way of squaring the circle, and also whether you agree with his analysis that we must assume that there may not be provincial legislation and therefore go it alone, as it were.
I don't think that it should be assumed that there shouldn't be provincial legislation. Medical aid in dying or physician-assisted death is related to both criminal law and health. And with regards to health, the Supreme Court of Canada has said that it is a matter that is a co-shared jurisdiction. It's a matter that belongs to the provinces, and it does belong to the federal parliament. It all depends on the perspective you have on the subject. It all depends on the nature of the intervention of the legislative assembly that is concerned. So I'd say that you cannot assume that there will not be provincial legislations or that there should not be provincial legislations. What could be done, though, is to talk with the provinces, discuss with the provinces, enter into a dialogue and see how there could be a concerted action with regards to physician-assisted death in order to give more harmony and coherence to both the federal and the provincial interventions. As for the Quebec law, I would say very briefly that the Quebec law could be a very good model across Canada, but it doesn't go as far as the Supreme Court of Canada appeared to have gone in the Carter decision.
Well, if I may, then that reminds me that on page 57 of the report, you make it clear the court didn't limit its decision, as Quebec did, to terminal illness, but it went beyond that. I wonder if you could tell us more about the boundaries you might suggest for the terms that are used in the Carter decision. Grievous and irremedial, for example. Do you see a need to define those terms, or would it be preferable simply to leave it to the courts to pour meaning into those terms over time?
Yeah. Of course, some people argue for these terms to be defined, and some people argue for the opposite. Those who argue for these terms to be defined say that, in fact, these terms could be interpreted in different ways. and that the physicians who will be facing the physician-assisted death situations won't know how to define necessarily these terms, grievous and irremediable. And they say that it would be good that in the law, these terms be defined. At the same time, these are terms that are very difficult to define. We consulted many people, as you know, and when we asked people to give us or to propose to us a definition of these words, no one really came up with a definition that could be put in a law, to be frank. And most people were saying, well, I've thought about it. I think it would be a good idea to define these terms, but I still have to think about the way that these terms should be defined.
Thank you.
Of course, the dictionaries give the definitions, but these definitions
Thank you very much.
do not help us very
Senator
much.
Nancy Ruth.
Thank you for your work and being here tonight. In your issues book, you ask Canadians in the eligibility scenario number 3 whether they should be able to receive physician-assisted death based on advance directive. 62% of the balanced representative sample agreed or strongly agreed. Am I correct that this scenario for advance directive received the highest level of support of any you proposed?
Well, the fact is that this question of advance directives is not a question that we have examined as closely as other questions. And I think that it would be good that this committee or other institutions eventually pay more attention to that specific question of advance directives.
Happy to do so, but my question was that in your report, 62% strongly or strongly agreed or agreed that this was a good thing. Is that correct? And that it received the most support. While the Secretariat is finding that question, I'll just go, the answer to that question, I'll just go on. One of the things that amazes me about when we talk about the other jurisdictions is that all the Benelux countries, Switzerland, the states in America that have physician-assisted death could all fit within Canada, and we'd still have space. So the geographical framework in which we are making these decisions is, I think, very important, although we might not have all the population that those countries combined do. So my question is around wait periods. It's been suggested in other testimony that waiting periods may be a safeguard to consider. There is no way for Parliament to choose a waiting time or periods that will be fair to all, in my opinion. Is there any reason that timing cannot be decided on a case-by-case basis, given the size of this country and the lack of complete medical facilities in many places, between an attending physician and the patient, or those who hold powers of attorney for the patient with prior directives?
Yes, when you refer to the geography, of course, it is a challenge for Canada because many people live in very remote communities in Canada. And some people express concerns that these people living in remote communities would not have a fair access to physician-assisted death. And this is what brought some experts to suggest to us that there could be an itinerant group of physicians, an itinerant group formed by medical personnel that could travel and make sure that there is access to physician-assisted death all across the country, even in the very remote areas.
So does that mean that a patient and the doctor...
I'm going to let him finish and get your first question because we're running out of time.
62%.
Do you have an answer, or would you like to respond after the meeting?
What I see in the report is that it's concerning the representative sample for the question, to what extent do you agree or disagree that you should be able to receive a physician's assistant to die if you now have advanced dementia and cannot make decisions on your own? The answer was 42% of people strongly agreeing with that.
And agreed? There were two. Strongly agreed and agreed. Combined? My understanding is they made 62%.
Combined, it's 62. There is
Thank you very much.
20% do agree and 52 do strongly agree.
Thank you very much. Senator Joyal.
Bienvenue, Monsieur Pelletier.
Welcome, Mr. Pelletier. I would like to go to page 59 of your report. Emancipated minors. Essentially, the Carter decision, as you know, refers to competent adults. Yesterday, Professor Hogg responded that in the criminal code, there can be different standards applied. One can be an adult at 21, at 18, at 16. In the Carter decision, it was established that a competent adult had the right to physician-assisted dying, but they are not limited by the Carter decision or limited to a strict interpretation of the term adult. Parliament is the one that must define what should be one's mental capacity to express a decision or intention. As a professor of law, independently of what you indicated in your report, especially Ontario's Act on Minorities' Consent, or minors' consent rather, the age at which a minor can express their agreement with a treatment or disagreement.
Vous avez une opinion à suggérer?
Do you have an opinion to suggest to the committee on the approach that should be taken to define accessibility in terms of age? First of all, I have to say that, yes, you are right. Canada's Parliament can go beyond the Carter decision. The Carter decision established the principle that physician-assisted dying should be available to an adult. And one must determine when one is an adult, who is an adult, but the Parliament can go further than that. Parliament can try to offer physician-assisted dying to minors who can make those decisions. For many people, the question is, it's not linked to one's age, it's linked to one's ability to make decisions. So there is an opportunity for this Parliament to go farther than the Carter decision. In the case of Canada's Criminal Code, the age that is indicated is 18 years old. However, presently, among different provinces, the age of majority is 18 or 19 years old. It varies. It could be possible for this Parliament to determine which age one is an adult and then to apply the standard of physician-assisted dying the same way that it would be possible for this Parliament to open access to physician dying and offer it to minors who, I would repeat, have the ability to make that decision, but who are not strictly said adults. Within that framework, would it not be worthwhile to follow procedure established under Ontario's law? Ontario's law on consent to treatment, to medical treatment. This was passed in 1996. It's been established for 20 years. Perhaps we should look at this act, which allows practitioners, professionals, the role or the responsibility to decide on the individual's mental capacity. in case one is 18 or 21 years old. That is an option that the Parliament will have to look into. I would say that strictly from a personal point of view, and without dragging in the other members of the committee, I would say that eventually debates will go before the courts, and they will be based on the principle of equality, which is to say, the Supreme Court of Canada, with the Carter decision, made a decision on the basis of right to life, security, and liberty, but did not want to respond to the question based on right to equality, Section 15 of the Charter of Rights and Freedoms. Eventually, there could be cases brought before the courts under which people will demand access to physician-assisted death in the name of equality. Those who argued the most firmly for the application of physician-assisted death to minors told us essentially that suffering is suffering, regardless of a person's age. Obviously, that is a striking argument.
So you had noted from your experience in investigating the European jurisdictions that there was general satisfaction with the laws that when you visited them. And I note that several of them do actually have permission for mental disorders or psychiatric disorders as a basis for physician-assisted dying. But you noted certain things that were requisites, and one of them was the safeguard of transparency. I wanted to ask you a little bit about oversight. How would you describe effective oversight for a physician-assisted dying system?
That idea of oversight is quite reassuring for the population. Population like to know that there might be a body or different bodies collecting data, analyzing how physician-assisted dying is provided all across Canada, and maybe doing some study on the impact that it has on human rights in general. So I would say that there were many points of view that were expressed concerning the mission of an oversight body that would be created. Some thought that it should only collect data, and that the data should stay confidential, and that should be a public reporting and maybe a reporting to Parliament. Other people went beyond that and said that the oversight body should really do a social analysis of the impact of physician-assisted death, and maybe have money in order to give subsidies to scholars to do research on different questions related to that issue. And it's not clear either that there should only be one federal body. There could be a federal body and different provincial bodies. There could be only provincial bodies working cooperatively, working together. That would be an interprovincial, in fact, organization, which is possible. So when we hear the word oversight, we should not necessarily think about federal only. It may be federal, provincial, and territorial, but it certainly reassures people. And let me say this, in my view, there are four cardinal points, four fundamental points that are reassuring people or are important on that issue. The first one being, of course, access to physician-assisted death, at least as the Supreme Court of Canada has defined it in the Carter decision. The second is an efficient oversight. The third one is better palliative care. And the fourth one is robust safeguards for the vulnerable people. If you talk to anyone and you say, these are the four components of what is going to be the federal or the provincial intervention with regards to physician-assisted death, people will be reassured, because there will not be only access to physician-assisted dying, there will also be a commitment for oversight, a commitment for better palliative care, and a commitment for the protection of the vulnerable.
Tell.
Monsieur Pelletier, soyez le bienvenu dans votre Parlement et Monsieur le Président.
Welcome, Mr. Pelletier. I'm very pleased to see Mr. Pelletier again. When he used to be a member of Parliament in Quebec, and when I became an MPP, he was a professor and commentator. But I won't remind everyone what he said about my work. We can talk about that later. Mr. Chair, Mr. Pelletier, thank you so much for having done such rigorous work. In 5 months, having put together such a rich document with relevant information, I congratulate you and I thank you. 2 points I would like to raise: the issue of vulnerable persons and the subject that you know well, cooperative federalism and Canadian leadership, which you raised earlier. This is why we are here today. Healthcare is a provincial jurisdiction, but we need to know just how far that goes and when they start to touch onto the criminal code. When you mentioned Canadian leadership and cooperative federalism, I was wondering if you could express an opinion on two theories. The Canadian government can precisely define just how far healthcare can go, or, on the other side, the Canadian government can allow the provinces to define healthcare for themselves, but limit it to a certain extent with the criminal code in order to allow provinces to adjust to that. But the initiative, because it's healthcare, which is entirely provincial jurisdiction, the initiative would belong to each province. Every province would have time to conduct this debate, as occurred over a 6-year period in Quebec. The law should be more precise, or perhaps we should allow more room or more leeway to the provinces. On a personal level, I think that the federal government should allow the provinces considerable leeway in order to act. But it could also legislate on the questions of age, which we didn't raise, and perhaps legislate the conditions of residence. If there are different conditions of residence that vary from one province to another, there could be a certain amount of interprovincial tourism, as there exists a certain amount of international tourism. Should a province not have any conditions for residence? Age, conditions for residency are probably the two most obvious subjects, as far as I'm concerned, when it comes to the federal government's involvement. When we look at the issue of federal leadership and federal involvement, we can put forward several scenarios. The first scenario is that the federal government only deals with Canada's criminal code. It's relatively limited in scope. The second scenario, change Canada's criminal code, and Canada's Parliament will make decisions and adopt measures when it comes to eligibility and protecting the vulnerable. That means we've already gone further. That's the second scenario. Third scenario, the federal government could pass a framework piece of legislation, hoping that the provinces will voluntarily adopt it by strongly encouraging them to do so. Or the federal government could leave a great deal of room for provinces and territories to act, given that this has to do with health care in the physician-assisted dying file, which is the province's jurisdiction. As far as I'm concerned, I would like the federal government to grant the provinces a great deal of leeway. on a subject such as this, the federal government may get too involved because physician-assisted dying happens in hospices, hospitals, in palliative care centers, which belong to the province's administration. Obviously, we need to consider one's vision of Canadian federalism. For many years now, my vision is based on the existence of two levels of government in Canada, each one having constitutional responsibilities, not just one.
Chair. Thank you, Mr. Pelletier, very much. There have been suggestions, and you alluded to these in your presentation, that the federal government amend the criminal code to allow provisions of physician-assisted death by a regulated healthcare professional such as a registered nurse, acting under the direction of physicians or a nurse practitioner. Might we have the benefit of your view on this?
Yes. You noticed that the Supreme Court of Canada talked about physician-assisted death. And, but in French, we sometimes say aide médicale à mourir, which is, of course, larger. But the Supreme Court really talks about physicians. Although the Supreme Court says that the medical personnel should be protected, those who in the medical personnel participate in the treatment, they should be protected as well as physicians are. To be frank, I don't have any specific idea about if we should open the door for nurses or other members of the medical personnel to give the treatment or to do themselves the aid in dying. But I'd say this, and again, this is a personal point of view, and I realize how difficult it is for me tonight to at the same time represent my co-panelists and answer your questions as you probably are expecting me to do. But I'd say that it's the first time that Canada is facing the challenge of physician-assisted death. And I personally think that Canada should go very, I would say, with great prudence on that subject. Acknowledging the decision of the Supreme Court of Canada, respecting that decision, but at the same time understanding that this is new for our country. And we, as Canadians, will have to adapt to it. And when the adaptation will have been done, then maybe will there be other steps that will be desired by the population itself. But I'd say that at first we should be extremely careful not to go too much beyond the Carter decision. The Carter decision has indicated the destination, and I think that for now it's good that the destination be respected, but I wouldn't suggest this Parliament to go far beyond that. But again, it's a personal point of view.
Senator Cowan, you will have the last question, and we're going to have to turn around quickly because the next panel has to be out of here at exactly 8:30. 7:30. No, 7:30.
Thank you for being here, and thank you for the work that you've done. I wanted to return briefly to the question that Mr. Rankin asked you earlier about the proposition that Mr. Hogg, Professor Hogg, put to us yesterday, and get your view as a lawyer and constitutional scholar as well about the authority which the Canada Health Act gives to the Parliament of Canada to act and to move in areas assuming or if the provinces or territories do not act. I think what Professor Hogg was saying was not that we should assume that the provinces wouldn't act, but that we cannot assume that all of them will act, and all of them will act in a way that is consistent with Carter. So does the Canada Health Act give this Parliament authority to act in that situation?
I think that the Constitution in general gives this Parliament such jurisdiction or such an authority. Because, again, the Supreme Court said that health is a shared jurisdiction and did not give any description or definition of what would be the respective jurisdictions of the provinces and of the federal parliament. It could be through the Canada Health Act. It could be in an independent act, a standalone act, a new act on physician-assisted dying, for example. That would be adopted by the federal parliament beside changing the criminal code. I think that what is important, and again, it's a personal point of view, is this. First of all, if the federal parliament intervenes with regards to safeguards, it should also intervene in order to make sure that there is access all over the country.
To assure that equality of access and opportunity, if that's the proper term, there is a responsibility on the part of the federal parliament to
You're right. I wouldn't see the federal intervention to be just on some aspects of the question. That would be unjust, in my view. So if there has to be an intervention, it should be on all aspects, including assuring that there is access all over Canada, first. My second point is that I personally would like what Quebec did to be respected. In other words, I would like Quebec law, Quebec Act, to be respected and not to be jeopardized by any federal intervention. I'm sure that most...
we're both going to be cut off here in a minute, but I could just get the... I think that Professor Hogg's answer to that was equivalency, so that there could be a declaration of equivalency if a province came up to a certain standard, even if they did it in a slightly different way. Would you agree with that?
Yes, under the reservation that the Quebec Act does not go as far as the Carter decision itself.
Obviously, it has to be amended accordingly.
That's right. So that's a big problem. The fact that it does not fit the Carter decision absolutely well is a big problem in this case. But I would like to see what Quebec did to be fully respected. And to be frank, I would prefer cooperation, collaboration among the governments. And if there is one issue, Mr. Chair, when that cooperation is possible and where that cooperation is desirable, it is precisely this one.
I think that's a very important point to close on in this regard. Thank you very much for appearing before us. We are going to temporarily suspend the meeting 1 minute. We have to turn this around quickly. Colleagues, we have the second panel before us. We have the two co-chairs of the Provincial Territorial Expert Advisory Group on Physician-Assisted Dying, Jennifer Gibson and Maureen Taylor. Witnesses, you have a total of 10 minutes for your presentation, and we will be very efficient because we know you have to leave at precisely 7:30 to get out of here. Please.
Thank you so much for the invitation to join you. This has been what I would say, and I'm sure you're on the same journey right now, quite a journey to get our heads into some of these issues and to be able to come forward with a set of recommendations, which I believe you will have had an opportunity to review in the report that we had drafted, as well as a set of slides that were prepared. What we'd like to do, though, is to draw out a few highlights from that report and then really turn it over to you to engage with us with your questions in hopes that we might be able to provide some flesh on the bones of some of the questions that you may have. So we may not take the full 10 minutes, but really look forward to the conversation we might have. It was one of the things that when we started off on this work as the Expert Advisory Group, and I should note just by way of a little bit of background, it was 11 out of the 13 provinces and territories who came together to create this Expert Advisory Group. And one of the key messages that we received from them was that what they were seeking was to avoid a patchwork approach. And hence one of the reasons why they created the Expert Advisory Group was so that we could provide recommendations that would reflect the continuity of Canadian context across the board. In addition to that emphasis on avoiding a patchwork, we certainly heard from the stakeholders that we met with over the course of through written submissions and also through in-person consultations, the importance of collaboration across jurisdictions, which includes federal, provincial, and territorial, but also with regulatory bodies. And the more that there could be alignment and clarity across across those rules, but also real effort to work together to clarify these issues, that was an important message that we heard along the way. One of the things that we also heard consistently was the importance of having a strong legislative response, both at the provincial territorial level and also at a federal level, particularly in our case, thinking about where we'd like to spend some of our time with you, some reflections on where there might be some clarity within the criminal code that we heard consistently from the provinces and territories as particularly helpful for the work that they need to do within their own jurisdictional settings. The third piece, though, just to reinforce, was that we also consistently heard, and as also you've heard from the federal panel as well, that physician-assisted death shouldn't be treated as some sort of parallel set of activities isolated from a comprehensive set of end-of-life services for Canadians. And hence there was a strong message that we heard, and we also reinforced in our own report, for seeing physician-assisted death as part of an integrated end-of-life care strategy that would engage all levels of government, including the regulatory bodies, in a very effective way. So one of the encouraging things looking at some of the federal findings, and as well as our report, there was some nice consistency. I'm going to pass it over to Maureen to pick up on some of the pieces that we thought we would highlight with you related to some possible clarifications within the criminal code.
Thank you, Jennifer, and again, thank you very much for asking us to be here. I think you all have this slide deck. I think it was just handed out. So really the nub of it is on page 6, priorities to raise with the federal government. Jennifer and I will address a couple of these for you. And the first one is something that you just raised with Mr. Pelletier, or one of you did, and that's other health professionals who may need to be involved in physician-assisted death. We take a different view. We very strongly think that the Supreme Court decision, although it mentioned physician-assisted death, did not mean to exclude other healthcare professionals, and anyone who understands how healthcare is delivered in this country knows that it is delivered not solely by physicians. We heard very strongly from the territories where they said, we have fly-in communities where there is no physician, there is a nurse in a nursing station. And if we're going to guarantee access across the country, we have to give a mechanism for them to be able to assess patients using telemedicine in conjunction with physicians in other areas, as well as delivering it. I also want to say that nurse practitioners, if you're not familiar with them, they have a standalone scope of practice that absolutely should encompass end-of-life care. And so we're asking that when you redraft the criminal code to carve out the Carter decision, that you make it clear that other healthcare professionals, nurses, pharmacists, I'm a physician assistant, by the way, be protected, but that also, especially nurse practitioners and healthcare professionals acting under the directive of a physician, be able to assess patients for their eligibility and to carry this out. That's an access issue. Then I also wanted to talk about the one of the later points about the definition of grievous and irremediable. Although Mr. Pelletier said they heard from people that they think it should be defined, but no one was sure how, we have a very strong opinion that it should be defined as sort of the common usage. It should be very severe or serious. And being somebody who works in frontline healthcare, I think we understand as healthcare professionals what that looks like. Very severe or serious. Obviously, acne is not very severe or serious. So I wanted to address those, and Jennifer is going to take a couple.
The other area of definition, and again, this is where we are focusing on some of the definitional issues because that was highlighted through our consultation as an area where clarity from the criminal code would be an enabler of some consistency across the province. One of the topics is the definition of adult. And if you look at, as was noted a little bit earlier this evening, that there are different ages of majority across the country, 18 and 19. In the area of healthcare, there is no age of consent in most of the provinces related to healthcare decision making. So what this means is there are a number of provinces who do actively recognize a mature minor rule in their which allows for the mature person under the age of 18 who is competent to be able to make decisions at the end of life. And so our position on this was that whatever definition of adult we might use, let it be a competency-based definition of adult, not one that is based on age. A couple of reasons for that. One is just simply that otherwise what we'd see is, again, current practice over a number of years has been that capacity has been the driver of the whether or not somebody is able to or should be able to consent to a treatment at the end of life. That would involve a very significant practice change for which there's no justification for that in other end-of-life situations. And the other is as well that competency really gets at the heart, we believe, that the Supreme Court of Canada was going for here. Somebody who can voluntarily choose to take a direction either for self-administered or physician-administered death according to these criteria because they are competent to make such decisions, because they believe it is in their own interest or because it is consistent with their values. Competency is the key to being able to do that, not someone's age. And I think perhaps, unless there's anything else you want to pick up,
you know, those are the highlights, but obviously we're here to answer your questions on anything else as well. Thank you.
Thank you very much. It was very effective. Monsieur Arsenault.
Merci, Monsieur le Co-président.
Thank you, Mr. Co-Chair. Thank you for your work and your presence here. The first recommendation in the list of recommendations of your report indicates that provinces and territories should work with the federal government and should implement a pan-Canadian strategy with regards to palliative care and end-of-life care, including physician-assisted dying. Yesterday, Professor Hogg spoke to us, as well as Mr. Ménard, and today Mr. Pelletier. They're trying to tell us that there must be a pan-Canadian strategy. Can you elaborate on that? Why is this part of your very first recommendation? Why did you feel the need to make it the first recommendation?
Thank you for the question. Well, I'll be very blunt. Of course, palliative care, there needs to be better palliative care. There needs to be better access to palliative care. I sometimes think we overstate the lack of palliative care. I was watching some of your panelists from earlier in the week, and I think that sometimes the statistics that are used, if you check, are very outdated. My husband had excellent palliative care, so did my mother, and the provinces have been working hard to improve this. But what we were seeing before our panel convened were those who were opposed to the Supreme Court decision were saying that we should not bring in physician-assisted dying in Canada until every Canadian has access to good quality palliative care. And of course, in our country with the universal health care system, we will never have Cadillac quality access to anything. It's, that's just the nature of the system. And so I personally didn't want that issue to get in the way of us moving forward. So I believe in a pan-Canadian approach to palliative care very strongly, but I also believe strongly that as we move toward that, we should not let people suffer in the meantime as they want to end their lives, end their suffering when they meet the eligibility criteria in the Carter decision.
Okay. Est-ce que vous suggérez qu'au Canada, il y a justement...
Do you suggest that in Canada there is a lack of strategy from coast to coast in this matter?
There's a lack of strategy. There's a lack of resources, no question.
J'aurais une deuxième question. Votre recommandation...
I have a second question. Your third recommendation says that provinces and territories should ensure access to physician-assisted dying, including both physician-administered and self-administered physician-assisted dying. That goes a little bit farther than Quebec's Act, which has just been passed. Could you elaborate on recommendation number 3 and why you made this recommendation?
So in our analysis of this issue, the Carter decision left room for both self-administered and physician-administered death. We look at number of jurisdictions. Some jurisdictions provided self-administered death. One of the limitations of a self-administered death only approach is that for those who might not be physically able to self-administer, then they actually it actually creates a barrier to access. On the other hand, physician-assisted death, that is, physician-administered death, was one that was very clearly one that had been identified in other jurisdictions as desirable, and we certainly saw that they were quite successful in introducing both. So there are going to be some Canadians who are going to say, I would really like to take ownership of this particular decision, and I would like to be able to determine the time of my own death, and I would like to be able to administer it. Others are going to say, you know what, if I'm suffering intolerably and I'm unable to administer, I would like someone to help me. I would like to be competent, I would like to be at the time of my choosing, I need help in order to be able to do that. And I think we owe it to Canadians to be able to offer both of those options to them.
Thank you. Mr. Cooper.
Thank you. My question relates to recommendation 29 of your report, wherein it is recommended that physicians file a report with a review committee to ensure compliance. I note that this regime exists in every Benelux country, and notwithstanding that in the Benelux countries we've had euthanasia for about a decade or longer, depending on the country, in only one instance has there been a public prosecution, and that was not the result of any report. It wasn't the result of the work of a committee or a review board. It was the result of a physician who spoke too much and too openly in the media. So in that context, I was wondering what reasonable assurance can we have that the reports that are submitted to such a committee will be accurate?
So this is an issue that we've heard crop up a number of times, whether or not there should be retrospective review or pre-review of all cases. We spent a lot of time thinking about this, and we heard testimonies about it as well. One of the concerns that was often raised was, well, look, unless we have pre-review, then we're going to see physician abuses happening. And our concern with raising such a concern was that would actually apply to almost other end-of-life decision that we currently have in Canada today. We do not pre-review end-of-life decisions on a regular basis in hospitals and hospices all across Canada now. So there would need to be a strong justification for diverging from this practice in the case of physician-assisted death. We are also concerned, too, that by introducing a pre-review process, it would actually create an undue burden on Canadians, many of whom are going to be entirely competent to make these decisions, who will be very settled in their views, have gone through the process, and that they will be very clear that this is the choice that they would like to make, and there will be no controversy about whether or not they're competent. Again, many of our health professionals are very skilled at being able to assess that level of competency. And so to introduce a pre-review would actually create an undue burden in many of those cases. So we have gone in the direction of retrospective review. And that's an important step. The retrospective review is extremely important because it gives us an opportunity to be able to learn from what the experience is within our system. We need to be able to monitor. We do need to be able to track data. We also need to understand where we are seeing certain patterns emerging, and that is going to be something that's going to enable us to continue to evolve and improve the policies that support this work. So we were finding a right balance in our recommendations to find a right balance of not unduly burdening patients, but ensuring that there were sufficient safeguards through the process up to the point of that individual finally having assisted death, self or physician administered, that those safeguards were up to that point, not adding an additional judicial review, tribunal or otherwise. I don't know if you want to add something to that.
And as a result, it is your recommendation that this decision be left entirely with physicians. And in my opinion, this would seem to be putting physicians in a very tough position, having regard for, on the one hand, applying, in many instances, a complex factual matrix to a complex legal regime. How are physicians equipped to do that?
Can you be, what are we leaving in the hands of physicians?
Well, you are leaving in the hand of physicians the ability to make a determination as to whether or not this procedure can go forward without any further authorization to physicians.
Physicians is what we said, and the eligibility is the Carter decision, and patient has to be diagnosed with a grievous and irremediable condition. Physicians make these decisions with their patients every day. Every day, physicians are talking to talking to them about when is it time to withdraw chemotherapy? When is it time to, in terminal sedation, which is basically how my husband died. So those are discussions that physicians are assessing their competency to make these decisions every day. There are physicians who will not be comfortable with this, and we say very clearly they shouldn't have to participate. It's for physicians who have that relationship with their patient and feel that the patient meets the criteria and want to move ahead with it.
Thank you. Mr. Rankin.
Darren, thank you very much for your excellent work. I wanted to sort of step back from the specific recommendations. As a colleague was pointing out to me, if you look at your long list of recommendations, very few are federal. Most of them are provincial, and some of them just simply confirm practices, with the colleges and so forth. So what kind of role do you envisage the federal government to play in this legislation? Because we were reminded that a province may not do anything, may choose not to do this. And so I'm kind of trying to square that with your approach and the recommendations.
Well, that's an excellent point. Indeed, most of our recommendations were focusing on the provinces and territories, in part because they were wondering about what their scope of role ought to be. But you're right. One of the key messages that we did here was, and this is it's embedded there, but it's probably worth unpacking a bit. What we were seeking was clarity, as we've noted, in the criminal code carve-out related to health professionals, related to eligibility criteria, and so that those would apply in a pan-Canadian way. We've also underscored, too, an important role federally for there to be federal oversight. And we heard earlier with the expert panel previously, we are actually envisioning 2 levels of oversight. So the federal level of oversight is primarily what would be more like a commission that would provide overall policy recommendations, would be a gathering, would gather data from across the country and be able to report back to the public on the state of end of life in Canada, particularly related to physician-assisted death. But then within the provinces, there would be a level of review as well. Now, one of the worries, of course, is we do live in a system that has federal government with a narrow scope of jurisdiction related to health care, and we've got provinces and territories that have, that's where most of the jurisdictional work is. And so we've been really, I mean, that's the system we've inherited, that's what we're working in. But one of the key messages that we took away from from our work with provinces and territories, they were the ones who were underscoring that they were seeking, did not want to see a patchwork. And many of them were saying, we need to just know what our marching, clarity on the criminal code issues, and then we will follow from there. So they were really looking for direction from the clarification on the criminal code from the federal government in order to be able to proceed.
Okay, time is so limited here. Recommendation 18, you call for, and you did in your oral remarks, a definition of some of the key terms, grievous, irremediable. Why? Just to push a little bit, why can't we leave it to the courts? We put all these words in the criminal code, some of them very general, and over time we have meaning for those words. Why would we want to perhaps narrow ourselves by putting words in a definition?
Oh yeah, we don't want you to narrow it. So that's why I said we just think, so irremediable has already been defined in Carter, because they said the patient does not have to try therapies that are not acceptable to the patient. So that's done. Grievous, we're saying very severe or serious. That's
Criminal code probably means already, that word already appears in the criminal code, so why put it down?
Yeah.
One of the reasons why we reinforced this was because there was a few voices that were starting to say, well, look, if you could just tell us what it means, we'd know how to apply it. But most clinicians say, well, that doesn't work for us. We don't know. But one of the key messages we heard was consistently, we want to know that when we're talking about grievous and irremediable, we want to know that we as clinicians are operating without incurring liability in what we do. We want to make sure we're following the rules, but please do not have it so narrowly stipulated that it's the following conditions cross that bar.
Okay, that's helpful. That's helpful, and no one's, of course, we all expect there be protections provided. I think everyone is on common grounds on that. Do I have any time left? Okay. Competent, the word competent, is that something we can leave the decision of whether a person is, quote, competent to the doctors, nurse practitioners? I think you made a powerful point about their role in this piece. Do we need that definition in our work or not?
We say in our report that provinces already have ways of when a physician is worried about a patient's competency, they seek other expert opinion, they send the patient on, and then where there is a disagreement between the patient and the physician over this, Ontario has a consent and capacity board. So we're saying let those things that are already in place take over this. So no, we don't think you need to address competence.
Recommendation number 12 and 13 on the timing of the completion of the Declaration of Competence, specifically about advance directives, if I might. And so you say on page 32, we recognize the rules about advance directives vary across the country, and therefore where a patient wishes to consent to physician-assisted dying in advance, you recommend a standardized patient declaration form. Could you help us understand your process of thought on this issue? Thank you.
Well, a lot of us, depending on the province you're from, I'm from Ontario, so I use advance directive, but you're going to hear in a couple days from Jocelyn Downey, who's a health law expert, and we'll defer some of the legalese to her, but she felt very strongly that that's not a consistently applied term across the country. So she actually believed that we needed to come up with a new way of letting everyone know legally what our wishes would be if we lost competence. And so she came up with the word patient declaration form, and so we're adopting that. But if you're more comfortable thinking about this in terms of advance directive, unlike some of your previous guests, we think that if you've been diagnosed with a grievous and irremediable condition and you're competent at the time of the diagnosis, you should be able to use some kind of advance directive to lay out your wishes in case you lose competence before physician-assisted dying can be administered. Okay? I think we go through 3 scenarios, so read the report, but there's a 4th scenario where we couldn't reach a consensus. Trickier. You're me, healthy, no diagnosis. I know that under certain conditions I would want a physician-assisted death, but some people on the panel felt you can't know what your wishes will be before you have the diagnosis. You can't speculate. So we say that the federal government and the provinces should get together and discuss this very serious issue over the next year and come up with some sort of resolution on that.
So could you give us some idea of the argumentation you went through? You said that the panel itself had difficulty with this issue, and certainly Quebec had difficulty with this issue because they ultimately took it out of Bill 52. So could you give us some of the input that you had when you discussed it in Provinces and Territories Committee?
Bioethicists take that.
So I think that there are a couple of factors here. When we thought about the most obvious example is a case of somebody who is competent, has a grievous and irremediable condition, and is suffering intolerably, and in that case it's very clear that they would be eligible. They meet the criteria, no question. But we have a very engaged Canadian citizenry. Canadians are starting to talk about death. We've got a number of initiatives across the country focusing on advanced care planning. We're encouraging Canadians to talk to their families. We're encouraging Canadians to articulate their values. We're encouraging Canadians to think about how they would like to die in other respects. And it is an evolving area of practice. It's an evolving area where we're starting on the one hand to see a much more engaged country of Canadians who are willing to do this, but it's still moving. So one of the things that we were thinking about was, within that particular context, how would this apply to physician-assisted death? I might be very clear that I might wish to end under certain circumstances. If I already know that I have a grievous and irremediable diagnosis, I may not be suffering intolerably, but I might want to have the opportunity to speak with my family, articulate my wishes, and then if I subsequently lose competency, but all of the other criteria are met, I would want my family to be able to exercise my wishes in that particular case. So there was consistency in some of the conversations we're having about advanced care planning and the situation where I might lose competency after having met the criteria. The more complex situation, though, is a situation where I might have gone through a number of those steps, but I'm not suffering intolerably yet. And in that particular case, I might have articulated what it would mean, what intolerable suffering would mean to me. And I might be able to spell that out in an advance directive of some kind. And so what we said was, in that particular case, that would be the expression of wishes that might be able to inform a decision to proceed with my wishes, which would be to end my life. So, I mean, I think we're seeing a convergence of conversations that are converging around physician-assisted death right now. There's still more work to do right now, but I think we're moving.
Thank you. Senator Cowan.
In Carter, the terminology that was used is grievous and irremediable medical condition, including an illness, disease, or disability that causes enduring suffering that is intolerable to the individual. Do you see any reason to distinguish between mental illness and physical illness?
Not for the purposes of being considered for this, but where I think we felt there could be leeway. You've talked about waiting periods, cooling off periods, and whether patients should require a psychiatric evaluation. We definitely don't feel every patient who asks for this needs to have a psychiatric evaluation, but I would think most physicians, where the baseline condition is your mental illness, and I think here we're talking about refractory depression most of the time, that most physicians would want that patient to have to have a psychiatric evaluation. I think that's just going to be good practice. So no, mental illness shouldn't exclude you under Carter, but will it require other thought processes? Probably, and I can see where those people would need to probably convince the physician over an extended period of time. And then there's the whole competency issue. Interestingly, we reached out to psychiatry associations, and we should not assume that just because someone has a mental illness that they are not competent.
The courts have been very clear on that.
Yeah.
One more question. The business of conscientious objection, and nobody was trying to force anybody to participate in this process. But the corollary of that, I mean, that protects the practitioner, whether it's a physician or another medical professional. But looking at it from the point of view of the patient, how do we ensure that that there is what I would call an effective referral? Something more than simply saying, well, I can't be involved in this, you're on your own, go and look it up on the internet, or you go call the medical society and they may be able to help you. Do you agree that we need to design a regime that ensures there is a more effective referral than that?
Yes, and this became clear this became clear to us through the consultation. We heard from many physicians who initially felt like this was weighing down a burden. This was falling only on physicians' shoulders. But on the issue of access, very clearly there are multiple actors that need to be operating together in order to be able to make this, to ensure access. What we've recommended is that in here we've defined roles for different levels of institutional roles, so regional health authorities to facilitate access. Quite apart from the issue of conscientious objection, access period is going to be a challenge for many in Canada. And so there is going to need to be system coordination, and that will be at the provincial and at the regional level within provinces, indeed.
The role of the regulatory authorities, colleges of physicians.
Regulatory authorities, indeed. And I think this is where the Supreme Court of Canada invited us to balance rights. And so we do acknowledge in clinical practice, and not just physicians, but other health professionals as well, that they have a right of conscience. And in fact, one of our members, Sister Noella Kenny, Dr. Sister Noella Kenny, who was a member of our expert advisor group, reminded us that conscience also applies to those who are proponents and are willing to practice physician-assisted death. Their conscience tells them that this is the right thing to do. And unless we need to be able to ensure that we have a regime that calls on physicians and clinicians to stay closely anchored to what they're called to do in terms of public service. So this is, the colleges do have a key role in making very clear what the expectations are of their members in terms of facilitating access. It's been very clear in our recommendations, and also we're hearing this from some of especially from the physicians in palliative care, that an effective transfer of care would be important, but that all physicians, all clinicians ought to be able to provide all information about all options. That doesn't mean that the physician needs to participate in the act of physician-assisted death, but they must be able to provide information on the options, and if necessary, on the basis of conscience, facilitate an effective transfer. And to do that well, they're going to need others in the system facilitating.
Exactly. Can I just make sure that you're also your comments would also apply to institutions?
Yes.
Yeah. Mr. Alday.
I didn't hear you.
Thank you. Just before I get started, I did want to take a moment and share just something very personal, and I'll be very quick. But when I shared with my wife, who's a physician, that I had been put on this committee, she immediately sent me a link, which was a YouTube link to the story of Dr. Donald Lowe. And I simply wanted to thank you, Maureen, for being here, being able to share and to acknowledge and honor the impact of your husband's life and also his death.
Thank you.
Thank you. And I'm going to share my time really quickly with my colleague Brenda. So I have two really quick questions. One of them, in the report, you talk about physicians refraining from this is in section recommendation 36. And I'm just really curious in your discussions about how big of an issue it was on physicians refraining from participating in physician-assisted dying, and if you see that that's a large issue that we need to pay a lot of attention to on the conscientious objection, and or just any quick thoughts on that?
Yeah, I'm not a legal expert, but I have a feeling that this is going to be seen as something that the provinces will say they have jurisdiction over. That's what we were told by the Attorney General. But I will say I love that you're thinking along those lines, because again, we don't want a patchwork approach to this. As we know, right now in Prince Edward Island, women cannot get an abortion. We do not want that to happen with physician-assisted dying. And anything your group can do to ensure, in the absence of province, this is one worry, I'll be blunt, is that some provinces will do nothing after next June. They won't bring in legislation, and I think you were talking about that yesterday. So if you can have something in place where those Canadians who live in a province that wants to bury its head in the sand won't be left without this option. I don't know what those things are. I'm not the expert, but I love that you're thinking about it. This is an issue that seems fairly uniquely Canadian. Of course, there are physicians who conscientiously object in the other jurisdictions, but as far as we knew from our research, it has never been such a mountain to climb as it seems to be in Canada, and I have no insight as to why that is.
Thank you. Am I done? Well, I had a very quick one, and then I'll pass it to Brenda. And simply, it's a struggle that I've had, and I don't know if you came up with this dealing with provinces and territories, is simply terminology. And as I go back and talk to constituents about physician-assisted dying, physician doesn't capture it, dying doesn't, or death. And I just wonder if that came up, and if you have tight terminology that we could be considering, and then I'll pass it to Brenda.
I mean, we eventually just went with the language that was in Supreme Court of Canada's ruling, of course, but we did hear some. I mean, there seems to be each of these terms could be unpacked and has its own controversies associated with them. So, I mean, consistency would be great. I mean, I don't know how to land on that, to provide any strong recommendation one way or the other, except
personal opinion.
We like the language we've been using.
I don't like suicide with this. I think it was yesterday you were talking about how Health Canada has a campaign to prevent suicide. That is precisely why I don't think suicide belongs in this discussion. I think that's a different issue. And the same, euthanasia, yes, this is technically euthanasia, but we know that has a pejorative connotation. I like physician-assisted dying or medically assisted dying.
Okay. So I'm just going to stick to, since we need to act on the Federal Criminal Code provision, and for us, our responsibility is to ensure that there's not a worse public evil. In your opinion, what is the worst public evil? Having the physician-assisted dying legislation or not having it?
Yeah. I think that public evil thing was in there as the way, that was how it was being explained when a federal law could trump provincial health care law. Again, these are better questions put to someone like Jocelyn Downey on Thursday. So the federal government can get involved in health care, which seems to be a provincial purview, when it's to correct a potential public evil. I would think like vaccinations might be an example. If a province wasn't going to make it mandatory for children to get certain vaccines, the federal government might be able to step in there and say that's bad for public health. And so if you're asking me,
seeing is that this report came from something's going on across the country, and it seems that this report is trying to address it.
We can't explore this if she hasn't got that figured out there. So, Mr. Deltel.
Thank you, Mr. Chair. Welcome, ladies, to the Parliament of Canada. I'll give you some time to put your earbuds in. Thank you. I would like to raise two issues with you. First of all, I'd like to raise the issue of terminology, but first of all, I would like to deal with the separation of provincial and federal powers. Earlier, the professor who was here, and it was very precise for him, he wants the proposed law to be open for provincial authorities, or perhaps more limited. Do we have to give more power to the provinces in order to decide the path to follow, rather than provide precise guidelines to the provinces? I would like to hear what you think about that. Do you think that the act that the Canadian government will propose should be very precise to allow the provinces to have more leeway, or would you like to increase leeway for the provinces?
So I think our recommendations were quite clear that it's really around definition and the scope of, particularly related to health professional role. That will be an issue that cuts across all the provinces. In terms of more prescription than that, I think that there would likely be some pushback from the provinces. The provinces do have jurisdiction over health. They actually have acts of legislation in place. I think it would make a bit of a legal quagmire for them, because each province is going to need to look at their own jurisdiction and figure out, given our current acts of legislation, given our current legal framework, what is the best way for us to be able to introduce physician-assisted death in our particular setting. Now, I think somebody mentioned earlier the idea of equivalency, and this was something that was surfacing for us, to ensure that Canadians have effective access wherever they happen to be, and ensuring that there's a legal framework to do that may mean that there are some provinces that might have a single act of legislation that captures the whole, and others might actually have omnibus legislation perhaps that makes revisions to what they've got, but the effective result would be that all Canadians and all provinces and territories would have access.
So do you think that the provinces and territories will welcome that kind of attitude, to let them decide where they want to go, instead of the government, the federal government, saying this is where you have to go, period? And let me remind you that it took 6 full years in the legislature of Quebec, under 6 different governments, 6 different premiers, to achieve that goal. So do you think that the provinces will welcome the fact that they will to decide by themselves?
Yeah. So one of the statements in our report says we advocate for moving forward on this at whatever level will achieve consistency across the country and prevent a patchwork. And I think we thought we were talking to the provinces. That was our mandate, provinces and territories. But if you think that you can, without encroaching on something purely provincial, come up with something that will achieve that consistency, and of course, it would depend on how much it mirrors what we've recommended, whether I would, and this is me personally speaking, then that would be great. But you'll have lots of constitutional lawyers to advise you on what you can get away with as far as the provinces and what you can't. From our point of view, we want consistency across the country.
Quickly, it will not be a question, just a remark. It's quite important to define the wording. Let me tell you that in Quebec, we start the debate under the title suivant, l'aide médicale à mourir.
Physician-assisted dying, and it finishes with end-of-life care.
Not exactly the same word. So it's quite important to define exactly what word means in that situation.
Exactly. Senator Nancy Ruth.
Thank you for being here. I want to take your minds to vulnerable persons. What does vulnerability mean? Who are vulnerable persons? How will we recognize them? And what specific measures do you propose to protect vulnerable persons from being induced to commit suicide at a time of weakness?
One of the things that was pretty clear to us throughout our deliberation was that almost every patient that we'd be talking about in this particular conversation would be vulnerable in one way or another. So vulnerability was something that would apply to all patients as a whole who might be candidates for this. But there were some unique, there might be some unique types of vulnerability that we needed to be attentive to. We've already heard earlier about persons with mental health issues. Some concerns were raised about do they deserve more protection? And you know what, indeed, we want to ensure that they are able to make, everyone who is making these decisions is competent to do so. We've also heard that there may be certain social conditions that may impede someone's ability to make autonomous decisions. And so in thinking through this, we suggested a number of things. First of all, and this was reinforced, I believe, also by the federal panel, this is not a single decision. This is a process. And that process, as we've mapped out in the report, is a process that allows any patient who might wish to even start a conversation about physician-assisted death has the opportunity to do so. And that process might, if required, given the circumstances of this particular patient, might invite the opportunity for a competency assessment, which is common practice in medical care as it is. It might also involve an assessment or a conversation with a psychiatrist if there are concerns about whether or not an underlying mental health issue might actually be potentially, or it may be uncertainty about whether or not it might be having an impact on someone's competency, but not necessarily. And also that but one of the gaps that we heard consistently was that one area where there could be an opportunity for better training of health professionals would be in the area of assessing social vulnerability. Now, one could say, well, until we've got all of those social vulnerability resolved, we ought not to be implementing this. We weren't willing to go down that road. We thought that at this point, what would be more appropriate with two physicians having to sign off the eligibility criteria, the time through which somebody might be able to have these conversations, that we would provide a sufficient level of protection for all Canadians, regardless of levels of vulnerability, but that also there was more work that could be done in order to strengthen the skills and capacity of physicians and other health professionals to be able to be attuned to other types of vulnerability that might not be immediately obvious.
And I think we should be satisfied, too, that in Oregon, where they track this, the vast majority of patients who ask for physician-assisted dying and get it are the 3 Ws: white, wealthy, and well-educated. And it is not the socially vulnerable who get there. In fact, I think we should wonder whether the poor and undereducated will even know this exists in Canada and that it's an option, and we should be worried about them accessing it.
You, on the side, sort of referred to the social determinants of health, that there may be other issues that could help move perhaps someone away. That certainly is the position of the last panel, although they didn't talk about it. Do you want to say more about that? Why you don't, well, whatever you think about it.
You mean why we, so you mean poverty and homelessness
poverty,
and things like that?
lack of access, bad food, no housing. Homeless.
Right. We did hear from some stakeholders who said, until every homeless person has a home, they can't make a competent decision to choose between physician-assisted dying and palliative care. Well, again, we're not going to be able to solve the homelessness problem, and I wish we could, before June. So we have to move forward, but physicians every day see patients who fight with their families about what they want at end of life. Are you wanting mom to stay on that machine just because, you can't let her go? I even know, I've seen where families don't want to let them go because there is a disability check coming into the house. How sad is that? So everyday physicians see these situations and have to make decisions, and we think they can do it in this case too.
Thank you. Senator Joyal.
Come back on your recommendation 17, whereby you propose that competence should be substituted to age as a criteria to have access to physician-assisted dying. Could you explain why you remove the age factor? Because it could apply below 21, but it would apply over 21 also. Because if there is no more age factor, no more adult status, then of course everything becomes a matter of evaluating the competence. So could you explain why you propose that approach to the issue of age as a criteria of eligibility?
Yeah. So the key thing, you're absolutely right. So a 21-year-old who is not competent would not meet the eligibility criteria for the purposes of physician-assisted death. Age by itself would not be sufficient. And so that would apply on the north side of 18 or on the south side of 18. So, but also I think the other thing though that when we looked at current practice within healthcare, and this is not just in Canada, this is broadly, there's an increasing recognition, particularly in pediatric settings, that some children, but especially adolescents, have the competence and the capacity to make end-of-life decisions, and in fact are empowered and encouraged to be able to be active participants in that. And so we wanted to be able to acknowledge this, that what that turns on is not their age, not what their birth certificate says, but it's really their ability to appreciate and to understand their diagnosis, their options, and many of these children, adolescents, would have had a period of time where they may have been sick for a great deal of time. They may have reach a point where they say, I know this better than anyone else does. My life experience is far richer because of this experience. And this is one of the concerns, is that, well, a 16-year-old hasn't had the life experience to make such decisions. Well, many of us haven't had the life experience to make end-of-life decisions until we're faced with it. So, but many of these young people actually have the competency to do so. So we're not saying, let us liberalize to the point that any child who says, I want physician-assisted death, should have access. Stringency of this criterion related to competence is essential.
If I may, I would like to come back on the issue of initial consent given by persons who become incompetent later in their life. I would like to understand clearly what is the distinction between a will where a person provides that in a case where the person is suffering from an accident or another disease and the person loses totally his or her autonomy, the person can decide to opt for somebody to consent for not to be maintained artificially in life, which is suicide in a way, to decide that in such a condition you prefer to die. And what you've proposed, if I understand well, it would mean that when a person is diagnosed with a disease or a condition, a physical or mental condition that is irretrievable, that person could opt at a point in time to have somebody to express the consent to terminate their life. Do I understand well the condition through which you would add to the capacity of a person to decide when that person will be dying at a point in life because her physical or mental condition would be totally irretrievable?
I think the first one you talked about with the will, where you say, I wouldn't want my life maintained artificially. Unfortunately, sometimes you're not on a ventilator and you don't need resuscitation, but you linger in that state of, well, for lack of a better word, in a near vegetative state. And that's what some people are saying. My father says, that's fine with me. I don't mind. I'm not going to know anybody. My dad would say that's fine. I would say, for me, no. So the only way I'm going to get a death hastened is with a physician-assisted death. So we're saying that's going to be allowed if I made it clear in an advance directive what for me would qualify as intolerable suffering. But again, our committee said we've made that decision if you already have the diagnosis. If an accident, here's a good example, stroke. If I have a stroke tomorrow and I have an advance will, I'll survive the stroke. I might not have any capacity to speak or recognize my family, but I'm not dying either, right? That's too bad. I can't get a physician-assisted death because I didn't have the diagnosis before I lost competency. Do you see?
Thank you. Madam Shanahan.
I didn't want to go too far down this road because I really believe it is in the provincial competency, sort of the procedural and health administration aspect of it. But we're here, and that's really where your work was. So two things: what are the minimum safeguards that you would envisage? That's sort of on the federal side. But then, did you consider options such as multidisciplinary teams, working in this area, and if so, how does that fit in with safeguards and the physician-assisted part? Yeah.
Yeah. And it's an interesting question, because what we've laid out in the basic protocol, I guess, a series of steps here, which includes assessment of whether or not the patient meets the eligibility. First of all, the patient makes a request, their competency, all of the eligibility criteria are assessed. The first physician confirms that. A second physician must also confirm that the eligibility criteria are met. If necessary, at either of those stages, if there's concern about competence, then there might be a consultation with a psychiatrist or a sociologist or a social worker or so on. All of those steps are there, but what you've introduced is really interesting, and that's the multidisciplinary team. And one of the things that, this is where some of these recommendations actually speak to each other, but it's not nearly as explicit, but it was in the back of our minds, was that some of the ways in which a physician or a nurse practitioner, if it were to be extended to nurse practitioners, might get to know his or her patient is because very often they operate within a multidisciplinary team, where knowing the patient is actually speaking with the members of your team and getting to know through that multidisciplinary team. So these patients are not, the only person who speaks to the patient is not just the physician. It's the social work, the nutritionist, the physio, all of those folks, and the circle of care. And that they collectively get to know the patient, are able to provide insight. And yes, this individual is competent. Somebody has to make the determination of competence. But those other members do have a relationship with that patient and might be able to inform that. And what we've tried to do here is acknowledge that that is in fact the way healthcare is currently delivered. It's also being established as a standard of care that we ought to aspire to see interdisciplinary teams circling around the patient in a way that actually meets the comprehensiveness of their needs. And so what we're trying to do is align some of what we're recommending here with what is emerging as best clinical practice from a patient-centered perspective. I'm not sure that quite answered your question, but
Yeah, no, I think that gives us some reassurance on the safeguard part. And you said right at the top that the patient makes the request, and I think that's a key concern too, that it's not something suggested to them, that it's the patient activates that request. In my work with living wills and, mandat en cas d'inaptitude in Quebec, mandate in case of incapacity, one thing that we were always careful to say, I'm a former social worker and financial planner and did a lot of this, what happens if you were to die today, or what happens if you were to be in that state where you can't make a decision. One key element was talking to your family, because you can't predict every situation, and that would be a concern that I would have about advance directives. Do you want to speak to that? Talking to the family, what about family reactions?
So we do not believe the family should be able to overturn a patient's request if they don't agree, if the patient wants this and is competent. And at the same time, we don't believe a family should be able to initiate this for a patient, whether competent or not. So a substitute decision maker cannot request physician-assisted dying, in our opinion.
Okay.
Thank you very much. Well, thank you very much for being here. I think we're going to get you out exactly on time. I need to inform the committee that for tomorrow, there's been a slight change in time. The first panel will begin at 5:15 to 6:15, and then we will take a suspension and begin the second panel from 7 until 8 p.m. Has everybody got that? Oh, right. It's due to a vote in the House, so I have to get your agreement on this. Are you agreed to this? And we're at Wellington, right? Yeah. 5:15 to 8 p.m. in total, right. But there will be a break between 6:15 and 7.
Thank you.
Notices to confirm. Notices will be sent to confirm it, okay? With that, I declare the meeting adjourned.